Hello and welcome to another episode of Vienna Arbitration Talks. Today I'm very happy to host here with us Annette Magnusson, who has come here all the way from Stockholm. Hi Annette, welcome to Vienna.
Thank you for having me.
Very happy to have you here. Just to introduce Annette briefly, Annette is the Secretary General of the Arbitration Institute at the Stockholm Chamber of Commerce. And this is one of the most renowned arbitration institutions out there. I have looked at their website yesterday and I saw that the aggregate amount in dispute in 2018 amounted to 13.3 billion euros. Now that's quite a lot. I guess, Annette, you have had some new big cases coming in. What kind of cases are these? Are these mostly commercial cases, investment cases?
So if you look at the caseload in Stockholm, it's sort of both commercial cases and investor state cases. And most investor state cases are quite large if you look at the amount in dispute. So that's one category of large cases. But also within the commercial cases, we see quite a fair number of energy-related cases in Stockholm. And also in this area, there tends to be a number of very large cases.
Oh, thank you. I should mention that in addition to Annette's day-to-day work as Secretary General, she's been quite a thought leader in new exciting topics in arbitration. She's been very active in a number of policy initiatives. I remember The Quiet Triumph, which is a documentary on the role of international arbitration in contributing to peace and security, prosperity in the world. Then Annette was also one of the initiators of a similar project, and I'm holding the outcome of this project in my hands now. It's a book called Arbitrating for Peace, How Arbitration Made a Difference. So this book focuses on the geopolitical role of international arbitration in the previous centuries and contains some examples on how arbitration has contributed, resolved disputes peacefully, disputes that could have escalated into violent conflicts. Annette, could you tell us more about the book? How has arbitration made a difference?
Well, I think the idea behind the book and also the film was really this sense that so much success, so much very constructive ways of resolving disputes was completely unknown in sort of the general debate or general discussion on the role by international arbitration. And what we wanted to do with the book and with the film was really to sort of uncover these success stories and demonstrate how this very constructive tool that we know as international arbitration has contributed to, at some points, even avoiding war. But, you know, the headlines rarely consists of conflicts that never happened. So the way these disputes were resolved just went away quietly. But I've always believed that international arbitration is a very strong testament to governments or states' willingness to be constructive in the relations. So not only have they designed rules for due process in international disputes, international arbitration through, for example, UNCITRAL, but they have also applied these in a number of different contexts with a very good outcome. So it was all about sort of opening up a door, if you want to call it that, to a large of unknown stories and inspire and send a message of hope and be positive.
How did you come up with the idea for these projects? I mean, it's quite interesting that you have decided to show also the others, people that are not really that familiar with arbitration, that arbitration can be done for a good cause.
So the idea with the film was born when we started to think about how we should celebrate the centennial of the SSC. So the SSC was founded in 1917, so 2017 was 100-year celebration. And of course, a few years before that, we started thinking about this. And about the same time, there was a lot of debate in Europe, but also outside of Europe, on the role of international arbitration. And I found that debate very frustrating. I'm a firm believer in the powers of international arbitration, and there were so many misconceptions flying around that made me frustrated. And again, going back to what I said earlier about, I think international arbitration is a great sign of strength in the collaboration between states. So we started thinking, and it all sort of came together, trying to sort of tell the story of how international arbitration developed in Stockholm. And also there you have a very interesting example of how in the 1970s during the Cold War, the Soviet Union and the United States, even though on the political level they were having a lot of conflict, so to speak, whereas there was very pragmatically, there was also commercial contacts and they needed a venue for the dispute resolution, and that's how it started in Stockholm. So this all came together as telling the bigger picture of how international arbitration in the big fabric of international relations has really been sort of like an enforcement bar throughout not only the last century, but even before then, in these constructive relations between nations and also in the commercial relations. So it all sort of came together with the film. And somewhere along those lines, the idea for the book was also born. There were so many interesting cases that we felt needed to be shared. And if I can share another story about the book, because we had an idea of the cases we wanted to have in the book, but we also wanted to have not only the established names, but also the new generation of arbitration practitioners or lawyers. So we had one chapter that was devoted to a competition where we invited practitioners to submit a chapter on a dispute of their choice. And then we had more than 10 chapters, I think, that were submitted. So much interesting to read. And eventually one of them was included in the book.
Thanks, Annette. Let's then go to our main topic for today, arbitration and climate change. Now, we're all finally becoming aware that something needs to be done about climate change, and it has to be done fast. Luckily, we have some Swedish people to remind us of all this, and you have been quite active in researching what we arbitration practitioners can be doing for the climate. Now, international arbitration and climate change do not really seem to have many overlapping points at first glance. If we start with international legal instruments dealing with climate change, they don't really contain enforcement provisions that arbitration practitioners are used to see in the treaties and contracts we usually deal with. So do you think that member states to these instruments are likely to be agreeing on enforcement mechanisms like arbitration to ensure compliance?
Now, if you look at the entire area of international law that we know as international environmental law, there are very few strong enforcement tools within this entire part of international law. And of course, if you look at the international investment law, the situation is the opposite. And I do think when we're looking at such a global challenge as climate change that affects everyone, we need to start moving in between the silos and see if we can cross-fertilize different areas of international law for sort of the bigger picture, for the common goal, long-term goal. So one of the ideas that we have been talking about is sort of trying to find ways in where international investment law and climate change ambitions actually can work together for these long-term targets.
You've mentioned cross-fertilizing between treaties, between different fields of law. How does that work?
Yes, I think between treaties, between different fields of law, to when cases are argued, look beyond the immediate area where you are actually initiating the case. Could there be other treaties or other instruments of international law or elsewhere within the legal sphere, so to speak, that could be relevant when you're arguing your case, for example? That could be one way of doing it.
I watched your 2018 speech at the ICCA Congress in Sydney, and another aspect that you mentioned there was potential claims of investors against the state failing to prevent damage caused by greenhouse emissions. Could you tell us some more about such claims?
So I think we don't have any examples of that, I think, to my knowledge, at least yet, but there are examples from previous investor state cases where investors have argued that the fact that a government did not live up to its international obligations under another international instrument within international environmental law, that fact has been one of the facts that have been the foundation of the claim when they're arguing a breach of the bilateral investment treaty itself. So there you can see some cross-fertilization between different treaties.
So basically a breach of the international treaty about climate change or about environment protection was then linked to a breach of the bilateral investment treaty.
Yes, in this particular case, it was not the climate change as such, but it was an environmental agreement. But I do think that that's just one example. And I think if you look at what we know as climate change litigation, there you see even more cross-fertilization, where you bring obligations on an international level and you bring it down to the national level, and this is how you argue your case before a national court.
Let's look at commercial arbitration a little bit. According to an UNCTAD report, foreign direct investment plays a key role in building low-carbon economies, and we are now expecting a surge in the carbon-neutral industry. There's new technologies that are being developed, there's new contracts that are being concluded. What are the challenges for commercial arbitration in ensuring enforcement of these contracts?
I think if you look at commercial arbitration within different areas, many of the core elements of commercial arbitration are the same in any different area you're looking at. If you're looking at environment, or if you're looking at construction, or if you're looking at finance, for example, right? So what the core elements of what we know as a due process and that we recognize in international arbitration will be the same. But I do think if you're looking at climate change, there are some elements we could be discussing. Should we want to do that differently than what is the norm currently? One of them obviously is the expertise of the arbitrators, understanding sort of the context, but then again you have that in any area which is specific, right, where the case is being heard. But another one that is very, that we connect very much with international arbitration, in particular commercial arbitration, is the issue of confidentiality. And I do think that we could start having a discussion and exploring, could we treat confidentiality potentially different if we're in a climate change context? Because if we want international business to all contribute and to learn from each other on how they best can do that contribution, but also policymakers on how they can learn what are the perceived or actual obstacles for these investments to actually happen. If we want these conversations to happen, to learn from each other, so to speak, I do think there's probably much to be learned also from disputes. What caused this dispute? How should we make sure that whatever caused this dispute will not be an issue in the future, potentially, but also actually encourage more investments in the future? And to achieve this, it may be that we will have to be more transparent and rather not confidential, but actually be able to share more. So I call this sort of the climate change related dispute intelligence. Should we try to have more of that? I'm thinking perhaps that could be a good thing.
Yeah, we should probably be discussing this. I was wondering about this. We have a particular special insight as international lawyers into business transactions, into international business. A lot of these transactions have quite a bearing on climate change. How can we ensure that with our daily work we do our share, we contribute to climate change mitigation?
The answer to that question will probably differ very much from depending on what kind of deal you're negotiating or what kind of context you're active in. But I do think that we all, as professionals, we are lawyers, so we work with the law, we work with the agreements. We all need to do our fair share of trying to ensure that we have sort of a sustainable future. And whatever that means in the individual case, obviously will be different, but at least have those glasses on when you're reading the contract, when you're assessing the deal or the setup or whatever you're involved in, to think, what is the bigger picture? Where does this fit in? And have the courage to speak up if you think, well, you know what, I think here we should do it this way because that will reduce the emissions. And sometimes that might even mean that something will become more costly. Well, then you will have that conversation about that. But I do think if we all have those glasses on in whatever capacity we are acting, I think we will all be better off for it.
Oh, thank you. This brings us then to our final topic for today, the Stockholm Treaty Lab. It's again one of these groundbreaking projects that you at the SEC have thought of. Can you tell us more about it? What is the Stockholm Treaty Lab?
So the Stockholm Treaty Lab is a competition. It's a crowdsourcing exercise. And crowdfunding, many are familiar with that. That's about getting money to fund your project. Crowdsourcing is about getting the ideas from the crowd. And this is something we initiated at the SEC in Stockholm in 2017. That's when the competition opened for registration. And what we wanted to do was to create an international treaty that would sort of encourage investments in support of the Paris Agreement targets. And this should be a treaty according to the criteria of the competition that will be attractive to governments, attractive to investors, encourage the right type of investments, and that would be enforceable. So we had the competition open for registration for a little bit more than 6 months, and we had 22 treaties submitted to the SSC. Which was absolutely fantastic, the quality of the submissions that we received.
I have seen that there was quite a few of very renowned people that were working in these working groups. Huh?
When we in the jury sat and assessed all the texts, we did not know who the authors were for each specific text, so they were all sort of blanked out. So it was very exciting once we have sort of decided the commended teams, and then we were allowed to see who the authors were. This was sort of an exciting moment for us.
Well, you commended 2 teams. They're winning projects, right? Yeah. Can you tell us more about these projects? How do they look?
So they were very different, but they both contained very good ideas. So we thought rather than having one winner, we thought they were worthy both of sort of being commended. And one of them was very forward-looking in terms of the transition that needs to happen, and sort of categorizing different types of investments and understanding that governments will have different needs throughout the transition. So being sort of flexible in that, but really pointing at what the green investments as opposed to the non-green investments, and recognizing how that could shift or because of the transition. And the other one, so there was a lot of substantive issues there that were interesting. I mean, I'm just giving you the brief now. There's much more. So obviously the team members will be able to give you the better presentation that I'm giving you now. But and the other team also obviously focused on the green investments, and they had an interesting procedural model where they were using the Mauritius Convention as sort of a model how you can make a new instrument applicable as widely as possible, as fast as possible, one could argue. So that was interesting also, the jury found. So we have now had the opportunity to hear the 2 commended teams in different forums sharing their ideas going forward.
Do you have plans for a new edition yet, maybe?
Yes, I think it would be really good if we could do that. I mean, we are still sort of in the process of sharing the results of the previous round, so to speak, or the first round. And the interest is just sort of continuously growing. So just as when we plan the competition itself, we don't always know where this will take us, right? I mean, the entire design of the competition and how it all ended up, when we started out with the idea, we did not know how the competition itself would look like in the end. I was telling people we were sort of building the aircraft as we're flying it, right? So, and I think the same goes with sort of the sharing of the results and the idea of crowdsourcing international law. Because I do think that's, I mean, you have the takeaway on the content of the submissions. And I should say all of the submissions have been published on the Stockholm Treaty Lab website. So the commended teams, but also the other teams that agreed to have their submission published, because it's all about sort of impact. So the more ideas out there, the better. So that's one thing that is the result. But the second one is that we learned that you can crowdsource international law. I don't know if it's ever been done before, but it works. People are engaged. People want to contribute. And people from all sorts of different backgrounds and jurisdictions and expertise, they came together and they came up with all of these very good ideas. And I think that also in itself, for us, was extremely inspiring.
You have said that you are now considering ways to promote the outcome of the Stockholm Treaty Lab. It would be a pity, I guess, if these treaties, these texts weren't seen by the people that are actually negotiating the treaties. Do you have any plans in this regard?
No, you're absolutely right. The whole purpose of the exercise was sort of to feed good ideas into future treaty drafting or to government negotiators, for that matter. So we have had the opportunity on different occasions to have conversations with policymakers, both in Sweden and elsewhere. And I do find that when there is an opportunity to mention the fact that we did this exercise in the first place, after that, people reach out and they want to continue the conversation. So I foresee that hopefully will continue, and we will have more opportunities for the teams and the teams' ideas to travel into the policymaker minds and hopefully negotiation rooms. We will see.
So we see that international arbitration practitioners are actually doing a lot of good things to deal with the climate change. There is a lot of projects out there. Thank you very much for coming here today for presenting these projects that you have been doing to us. And for you, dear viewers, thanks for watching. If you'd like to see The Quiet Triumph, you can watch the full movie at the SEC website. And if you'd like to see our next video, please subscribe to our YouTube channel, Konrad Partners International Arbitration, and follow our hashtag Vienna Arbitration Talks. So this is all for today. Thanks again and greetings from Vienna.